Welcome to The Bottom Line. I'm Jan Helfeld, and our guest is David Kelley, the Chief Intellectual Officer of Atlas Society. We're here at the Atlas Summit. They have a great summit here where they're having a lot of different topics discussed, and he's the author of this whole production. Thank you for appearing on The Bottom Line.
Glad to be here.
The topic that seems to be on everybody's mind these days is whether the Supreme Court should have upheld the Affordable Health Care Act, also sometimes referred to as Obamacare. And I'd like to get your take on what you think. Do you think it was a proper decision, or anything you'd like to comment on that?
Well, I have to answer at two levels, Jan. In terms of the actual meaning of the Constitution, the entire concept of Obamacare is unconstitutional. The Constitution says nothing about the federal government providing welfare benefits of any kind, including health. Nothing.
We can direct the viewers to Article 1, Section 8.
Okay.
Enumerated powers clause.
It's not
on the list.
Enumerated power.
It's
That's
not
right.
one of
It's
those
not
19 there on
Yeah.
the list.
Right.
Okay.
But that battle was lost long ago during the New Deal, when the court decided that economic rights and property rights had lesser status than First Amendment and free speech rights, and that Congress was essentially authorized to do anything to regulate the economy under the guise of interstate commerce. So, they stretched the definition of interstate commerce beyond belief.
I want to talk about that later, yeah.
So, we are now living in the shadow of those long-standing precedents. And today, the court, operating within those precedents, had to decide the much narrower issue of pushing forward. Can you require people to engage in commerce in the first place? And the decision turned, as you know, on not the swing vote was Justice Roberts, whose argument was the individual mandate requiring everyone to buy insurance on its own is unconstitutional.
In the law called a penalty.
But because it was attached to a penalty if you did not buy your insurance, if you did not comply with the mandate, that was the equivalent of a tax, and taxing is okay. It's subject to a different standard. So that was pushing the ball down the field.
Just to be clear about this, the law talks about a penalty, doesn't talk about any tax.
That's right.
But the justice said this law says it's a penalty, but it's really a tax.
Yes. So there's a huge amount of bad faith here in terms of or bad dishonesty, because an important point in getting Obamacare passed in the first place was it's not a tax. It's just a penalty if you don't comply with the law. And now the Chief Justice of the Supreme Court has called that bluff. He has said, okay, in effect, you're opposing a tax. You may not want to call it that, but that's what I'm saying it is, and so it's okay. And now we return the issue to the people to vote on whether they really want Obamacare. So I don't think we can treat when the Constitution has been eroded as extensively as it has over a century. We can't put our faith in the 9 guys or the 5-4 majority of the Supreme Court to protect our liberties. We have to get out there and be activists about it, both through the democratic process, through argumentation, through media like we're doing now, through every means at our disposal.
But there's one interesting point that you were making implicitly, which is even Justice Roberts didn't want to stretch the Commerce Clause as far as requiring you to buy something.
Exactly.
And imposing a penalty on you for not taking action.
Right.
He said that Commerce Clause would not support that.
That's right, correct.
So he had to look for a different support, different constitutional support that he claimed, we both agreed doesn't, but he claimed did give it, made it constitutional, did give it support, and he went to Congress's authority to tax.
That's correct, yes.
And so it's interesting because even he wasn't willing to go that far with the Commerce Clause, right?
Yes, and so that does set a boundary now.
At least.
Yeah, now,
A very
the individual mandate requiring people, the idea that was covered by the Commerce Clause is so outrageous in the first place. That is the reductio ad absurdum
Absolutely.
of the expansion of power under the Congress, under the Commerce Clause. So now people are on notice. You can't go that far. But whether Justice Roberts was wanted to support the Obamacare and was looking for another way to do it, or whether he was just an honest jurist who was saying, you know, it amounts to a tax, and so I have to rule for it because it's, you know, the taxing power is different. I don't know the man's mind, okay?
Right, neither do I. We're both speculating, but it seems to me a man who wants to declare the law constitutional and is looking for any way out. And so he grabbed on this general tax power, which he claimed supported the law. But and you're a political theorist, and I want to pick your brains on this rather subtle issue, which is raised in my mind, with all this judicial activism and all these instances where the Commerce Clause says interstate commerce, and then they regulate intrastate, and they regulate what isn't commerce. They regulate everything, even if it isn't commerce. Right. It's not interstate, it's not commerce, they still regulate it. So this issue of statutes using words that then the justices interpret to mean something different than what the meaning of the word says. I see a great problem with this judicial activism because, in my view, it erodes the commitment to rule of law. And also, in my view, every society, in order to operate optimally, has at least two minimum requirements. People in the society have to be committed to the rule of law, and you have to have the right laws. If you have one or the other, it's not going to work. You need both. And rule of law depends on something that you as an epistemologist know very well, which is that the law has to have an explicit meaning. If it doesn't, if it can say penalty, and then you can say it's really not a penalty, it's a tax, or it's a banana, or something else, then the law doesn't mean anything, and people cannot commit to being in favor of following the law, rule of law, which is that principle, if the law doesn't mean anything specific.
Well, that's true.
Does that worry you as well, that this is eroding the society's commitment to law, because these justices can say that the law says anything they want it to say?
Well, at the level of the Supreme Court and the constitutional cases that come before it, and also the lower courts, the appeal courts, which actually make a great many constitutional decisions that never get to the Supreme Court but are therefore effective as precedents. At that level, yes, the meaning of the terms, much of the litigation turns on the meaning of terms, and the having objective meanings for those terms is extremely important. But I don't. I'm not. I know that the people the legal brains who operate at that level are very smart. They're as smart as I am, and they
you're
may not
smart,
have the right philosophy.
and I know.
Yeah, thank you. So they're very on any particular issue, like the mandate, the penalty, the taxes. They are very sophisticated argumenters. The danger at that level, however, is that the broad principles of the Constitution have been interpreted by generations of legal theorists and political theorists as it's called a living Constitution. The words change with circumstances. And that's, at that level, yes, this is a serious problem. The bigger problem, though, with the erosion of the rule of law is the growth of administrative discretionary law at the level of the regulatory agencies, where Congress says, okay, we give some regulatory agency, the Environmental Protection Agency, regulate carbon emissions and leaves it completely open for them to set what the standards are, what the rules are, and it comes down to a great deal of discretionary law, which is that's the real enemy, I think, of the rule of law. So that's where I think the bigger danger across the whole economy is. But you're right about at the highest level.
In this case, we don't even know what Obamacare is actually going to end up meaning, because a lot of the regulations are still being written.
That's right, exactly.
So here's all these people are talking about how great it is that now we have certainty, because now we have this law in place, now we know it's there. But I ask this question, can a law that's 2,600 pages long and requires thousands of pages of regulations to be made,
exactly,
can that remove uncertainty regarding the cost of health care and the requirements to get it?
Right.
If you don't know what it's going to say, how can it be certain?
I don't know as an individual. Companies don't know as companies what the requirements are. Tomorrow we're going to have a lecture by someone who's in that industry, Aaron Day, who's now the CEO of our organization, but he came to us from running his own organization in the healthcare business, which came to a halt because he didn't know what was going to happen. And none of his clients knew what was going to happen. He was providing a healthcare service to private businesses. So that would be it on this topic. He'd be a real resource. But you're right. The uncertainty comes from, right now, is a degree of uncertainty is removed by the Supreme Court decision, but there's a huge backlog of uncertainty as to what the regulatory agencies will do. And so the rule of law we're nowhere near the rule of law here.
And this issue of 2,600 pages of a law, can anybody really know what this law says? I mean, I haven't met a single person who claims to know what the law says. The congressmen and women voted on this law without ever reading it. The Supreme Court said they didn't want to read it. They said, you expect me to read this law? Nobody wants to read it. Yeah. And the people that have tried to read it have told me that they can't understand it.
Yeah.
That it's like, and these are lawyers.
Well, I'm one of them. I've not tried, frankly.
I haven't tried either. I know what to expect.
Yeah. I'm not going to spend my time reading that many pages.
It's incredible. I mean, don't people realize that at a certain number of pages, it doesn't really matter what the law says, it's just impossible?
No, that may be.
And I think 2,600 pages has reached the limit. Well, David, thanks a lot for the interview.
Right. Sure.
And I hope you have a great summit here and great conference.
Thank you, Jen. All right.
Bye-bye.